Good morning, friends. My today's topic is duty to the client. An advocate is bound to accept any brief in the courts or the tribunals or before any other authorities in or before which he proposes to practice at a fee consistent with his standing at the bar and the nature of the case. Special circumstances may justify his refusal to accept a particular brief. Secondly, an advocate shall not ordinarily withdraw from engagements once accepted without sufficient cause and unless reasonable and sufficient notice is given to the client. Upon his withdrawal from a case, he shall refund such part of the fee as has not been earned. An advocate should not accept a brief or appear in a case in which he has reason to believe that he will be a witness. And if being engaged in a case, it becomes apparent that he is witness on a material question of fact, he should not continue to appear as an advocate if he can retire without jeopardizing his client's interest. An advocate shall, at the commencement of his engagement and during the continuation thereof, make all such full and frank disclosure to his client relating to his connection with the parties and any interest in or about the controversy as are likely to affect his client's judgment in either engaging him or continuing with the engagement. It shall be the duty of an advocate fearlessly to uphold the interests of his client by all fair and honorable means without regard to any unpleasant consequences to himself or any other. He shall defend a person accused of a crime regardless of his personal opinion as to the guilt of the accused, bearing in mind that his loyalty is to the law, which requires that no man should be convicted without adequate evidence. An advocate appearing for the prosecution of the criminal trial shall so conduct the prosecution that it does not lead to conviction of the innocent. The suppression of material capable of establishment of the innocence of the accused shall be sacrificially avoided. An advocate shall not directly or indirectly commit a breach of obligation imposed by Section 126 of the Indian Evidence Act. An advocate shall not at any time be a party to fomenting of litigation. An advocate shall not act on the instruction of any person other than his client or his authorized agent. An advocate shall not stipulate for a fee contingent on the results of litigation or agree to share the proceeds thereof. An advocate shall not buy or traffic in or stipulate for or agree to receive any share or interest in any actionable claim. Nothing in this rule shall apply to stock, share, and debentures of government securities or to any instruments which are for the time being by law or custom negotiable or to any mercantile document of title to goods. An advocate shall not directly or indirectly bid for or purchase either in his own name or in any other name for his own benefit or for the benefit of any other person, any property sold in the execution of decree or order in any suit, appeal, or other proceeding in which he was in any way professionally engaged. This prohibition, however, does not prevent an advocate from bidding for or purchasing for his client any property which his client may himself legally bid for or purchase, provided the advocate is expressly authorized in writing in this behalf. An advocate shall not directly or indirectly bid in court, auction, or acquire by way of gift, sale, exchange, or any other mode of transfer, either in his own name or in any other name, for his own benefit or for the benefit of any other person, any property which is subject matter of any suit, appeal, or other proceeding in which he is in any way professionally engaged. An advocate shall not adjust fee payable to him by his client against his own personal liability to the client, which liability does not arise in the course of his employment as an advocate. An advocate shall not do anything whereby he abuses or takes advantage of the confidence reposed in him by his client. An advocate should keep accounts of the client's money entrusted to him, and accounts should show the amounts received from the client or on his behalf, the expenses incurred for him, and debits made on account of fees with respective dates and all other necessary particulars. Where monies are received from or on account of the client, the entries in the account should contain a reference to whether the amounts has been received for fees or expenses, and during the course of the proceeding, no advocate shall, except with the consent in writing of the client concerned, be at liberty to divert any portion of the expenses towards fees. Where any amount is received or given to him on behalf of his client, the fact of such receipt must be intimated to the client as early as possible. After the termination of the proceeding, the advocate shall be at liberty to appropriate towards the settled fee due to him any sum remaining unexpended out of the amount paid or sent to him for expenses or any amount that has come into his hand in that proceeding. Where the fee had been left unsettled, the advocate shall be entitled to deduct out of any money of the client remaining in his hand at the termination of the proceeding for which he had been engaged, the fee payable under the rules of the court in force for the time being, or by then settled, and balance, if any, shall be refunded to the client. A copy of the client's account shall be furnished to him on demand, provided the necessary copying charges is paid. An advocate shall not enter into arrangements whereby funds in his hands are converted into loans. An advocate shall not lend money to his client for the purpose of any action or legal proceeding in which he is engaged by such client. An advocate shall not be held guilty for a breach of this rule if in the course of pending suit or proceeding or without any arrangement with the client in respect of the same, the advocate feels compelled to, by reason of the rule of the court, to make a payment to the court on account of the client for the progress of the suit or proceeding. An advocate who has at any time advised in connection with the institution of suit, appeal, or other matter, or has drawn pleadings or acted for a party shall not act, appear, or plead for the opposite party. That's all. God bless you all. See you again.